Joining us now live on the South Shores of Morning News, we have special guest, Plymouth County District Attorney Tim Cruz. Thank you so much for joining us this morning.
Good morning, Christine.
I had a question for you. A judicial ruling, and if I mess this up, please correct me because I find this confusing.
Yeah.
But a judicial ruling on a man convicted in a murder case changed the judicial system here in Massachusetts, and it was the Mattis case. Can you explain a little bit about that?
Yeah, Mattis was a case that came down last year by the SJC, their decision, a 4-3 decision. And Mattis was a case that occurred in Suffolk County where an individual and his co-defendant were tried together for first-degree murder. Mattis had just turned 18, about 8 months before that. He was convicted of first-degree murder. Life without parole is what he was given. And the SJC argued, they wrote, and they agreed with Mattis in his arguments that, among other things, that his mandatory sentence of life without parole violated Article 26's prohibition of cruel and unusual punishment. And when you think about the case itself, Mattis was not the shooter, but he was the individual who planned the murder. He gave the co-defendant the gun. He pointed out where the victims were. He instructed his co-defendant when to commit the murder. There was no impulse. There was no sudden impulse. There was nothing emotional about it. It was business is what it was. Mm-hmm. And as a result of this decision now, more than 258 families in Massachusetts are going to have to deal with the decision of Mattis and go forward with parole hearings probably for the rest of their lives.
So in layman's terms, because of this, with these families, they who already sat through the trials and were given what they thought was a fair, as fair as it could be, form of justice to the perpetrator, that doesn't stand anymore.
Right. They were told that these cases were over. The individual obviously has a right to a fair trial, right to appellate review, all that stuff. And they were told that if you were convicted of first-degree homicide, which is either deliberate premeditation, extreme cruelty or atrocity, or felony homicide committed in the commission of a felony, that you get life without parole. What Mattis has done is changed and has moved a bright line of the age so that if you are an adult in Massachusetts, either 18, 19, or 20, that automatically you're going to get a parole hearing on your life without parole because of the decision of the SJC talking about dealing with emerging science regarding that the brain wasn't developed.
I'm a little confused here because the brain wasn't developed, but at 18 you can do a lot of things in this country.
Sure can. You can vote. You can join the Army. You can deal with your medical issues, but for whatever reason, rather than deal with the factual basis of these cases, which we do in every one. And when's the last time you've heard of a murder case being tried where somebody doesn't bring up, potential mental defects, diminished capacity, that individual has mental health issues, that individual's on drugs or alcohol? That's all brought up. Part of what we have to prove during the course of these first-degree homicide cases is that somebody has the appropriate mens rea, the appropriate state of mind, and therefore could they form the intent or not. So a jury makes that decision. And if the jury doesn't make that decision, the idea of moving the ball for the purposes of parole hearings is really a legislative issue. It's not a court decision. In this case, they made the determination that based upon some emerging science, which is just that, emerging, there's really nothing settled out there. Because there's also science out there that says when you're 16, you can have cold cognition and you can premeditate, you can plan, things such as that. So that's why you have to look at each case on that sort of basis. And the problem is that now, if you committed murder or convicted of first degree in Massachusetts, you have life without parole at 20 or under, you're going to have parole hearings in the family. The victims, the real victims, that's not the defendants, they're going to have to relive this every 5 years, every 3 years, every 1 year until they get released. That's what's going to happen. So basically, they're going to have these hearings ad nauseum until they get released.
Is the state of Massachusetts the only state that has this?
Absolutely. We're the only state in the union that have that.
Okay, now when we talked about legislative, let's jump back here for just a second because I'm just remembering 80s, early 90s, wasn't there some kind of a legislative trade-off for no death penalty, as I remember?
Yeah, absolutely. There was, if anybody recalls, maybe as old as me, back here in Massachusetts, there was a very lively debate on the death penalty, and it was defeated by one vote. And the biggest issue at that time as to why we didn't need a death penalty was that we had life without parole. So now we're in a situation where we're really moving in the direction of taking that away. And this decision by the SJC talks about, the contemporary standards of decency. So I think what we in the public have to ask is it decent for a family having to relive this pain and suffering forever, to keep going back and forth? I was at a parole hearing a month ago, where an individual was trying to get out. Him and another co-defendant murdered a 79-year-old man where they broke his back. They left him to die in a trailer in Middleborough. That family has lived with that for 38, 39 years. The pain and suffering is ongoing like it happened yesterday. And when you go to the parole hearings, the focus is on the defendant and what is he or she done in order to get out. It's incredibly frustrating for the family members who don't understand why. Why didn't you promise us that these individuals would never be out again? And now we're in a position where at some point they're going to get released. And if I was a family member, I would be just as frustrated as them and hurt that they've been lied to and they've been betrayed by this decision.
What can people do? I mean, is this a done deal? Is this something that may come before the SJC again?
Well, I'm sure it is, and I'm sure who knows where it will end up. I think that, that this is the decisions regarding what is the age majority of Massachusetts is really a legislative decision. So we should make sure that our legislators in the House and in the Senate understand what our positions are, because there are positions out there that want to continue to move the ball and move the age of majority from 18 to 20, 21. I hear as much as 25 or 26. And at some point, when are people going to be held accountable for their actions? And, as we go forward, my job is to speak for the victims. My job is to stand up for the people who don't have voices. And that's what we try to do in every case. And it's incredibly frustrating when we have these decisions that are coming down that we're going to have to deal with, which we will. But we need to fight legislatively to make sure things can maybe be put back in the bottle and we can stop this before it happens again.
That's Plymouth County District Attorney Tim Cruz. If people want to contact your office, what's the best way?
You can always call us at 508-584-8120 or PlymouthDA.com.
Thank you very much. Again, that's Plymouth County DA Tim Cruz.